Okay, if we could call the room, the courtroom to order. Who did that? All right. We are here, and I should have known. You stuck around for the second argument there. All right, we're here for oral argument on Jane Doe 1 et al. versus, is it War? Our number CV-25-0107, and you all just heard, you can keep whatever time you wish for your rebuttal, just keep your time yourself. Please proceed.
Good morning. May it please the court. My name is Kathy Brody, along with my colleague Ann Chapman. We represent defendant Shawniece War. I'll save about 4 minutes for rebuttal. This case is about subsection A5 of the Mandatory Reporter Statute, which is a criminal statute, and whether Ms. War, who taught Sunday school and occasionally babysat for plaintiffs, is encompassed by the language, quote, any other person who has responsibility for the care of the minor. The court should hold that this language means a person who is providing for the necessities of life for a child, including shelter, food, clothing, and medical care. It's a person who has custody of the child and is exercising supervision over the child in a parental way. It is a de facto parent, a person who has voluntarily assumed a structural relationship with the child, which is recognized by Arizona law. It doesn't include a babysitter, a carpool driver, a Sunday school teacher, neighbor, or anyone else who has informal, casual, or occasional contacts with children.
Ms. Brody, I think that you argue in your briefing, correct me if I'm wrong, that we should, in interpreting that language, refer to the other categories of people who have interaction and are mandatory reporters. Many of them have the most episodic contact with children. School personnel, that could include a janitor. A babysitter, by contrast, if you're babysitting an infant, you may bathe that child. That person may be in the very best position, and anyone who's ever had their children babysat know that just taking the words of the statute, not the words of the statute that you are characterizing, that a babysitter does have responsibility for the care of a child. While the parent is gone, they are it. They are in loco parentis. Why am I wrong on this?
So yes, Justice Bullock, you are wrong about that. And our position—
It wouldn't be the first time. Okay.
Our position is that a babysitter is not encompassed within the statutory language of a person who has responsibility for the care of the child. And this court's 1997 opinion in Jones is the key authority in this case because it limits the definition of care to a person who has custody of the child and is acting as a de facto parent. Now, if
Counsel, are you using the word custody in the legal sense, like legal custody?
Well,
like an order from the court? Is that what you're meaning by the term custody? Because I'm a little caught off guard by that.
yeah, and so the legislature uses the words care, custody, and control. It uses those words actually to reflect the same concept. And the concept is that a person who has custody and control over a child has rights and responsibilities that go along with that. That's whether you're a natural parent, whether you are a custodian who has been ordered by the court as a legal guardian, or the concept in Arizona law of acting as a de facto parent, I would say, or as Jones and Swanson and Smith put it, a person who voluntarily assumes the responsibility to provide for the necessities of life for the child. And that's what Jones says. And so I actually like to think of Swanson, Smith, and Jones as a trilogy because they happened in 95, 96, and 97. And this court's opinion in Jones, when you look at that, that was looking at the phrase care or custody in the child abuse statute, 1336-23. And Jones noted neither of those terms is defined by statute. So Jones looked to the dictionary definitions of the word, and care means charge, supervision, management, responsibility for, attention to safety and well-being. And Jones says the dictionary also says care means custody. The two are synonymous.
Counsel, let me ask you a question about that then, and focusing on A5. If we're reading A5 though, and I think your briefing asks us to do this too, if we read that in conjunction with the other explicit categories that are set forth, isn't that the same context in which we should read what care means? And the reason why I ask that is if I think about what care means within the statute, well, there are some professional positions in which care is provided. It's medical care. Now, the A5 also references treatment, but we're not dealing with treatment here, focusing on care. There's that care. Then there's the kind of care that a parent, step-parent, or a guardian of the minor might provide. But then I start to find a hard time trying to associate care with the positions of a peace officer, child welfare investigator, child safety worker, member of the clergy, and especially when we get down to A7, looking at any member of a school district governing board or charter school governing body. Any other person who has the responsibility for the care of the minor, I'm having a hard time limiting it to the argument that you're making so far about how we've treated those terms previously.
So I'll say this, Justice Montgomery. You don't have to worry about fitting the language in to those other categories because this is a criminal statute and the legislature has drawn the lines and said which people fit within the categories and which people are subject to this. Now, it's added, as you noted, it's added that subsection 7 recently to include school board members. It also recently added substitute teachers to the specific people who are covered by the statute. And the responsibility for the other person who has responsibility for care, our position is that it must refer only back to subsection A3, which is a parent, step-parent, or guardian. That's what care refers to under the meaning of Jones and Smith and Swanson, where those cases say that in order to have responsibility for care of a minor, the person must voluntarily assume the responsibility to take care of the necessities of life. And actually, if you look at those cases, and I would say Jones and those two cases preceding, Smith and Swanson, as well as the court's most recent opinion in the Samantha Allen 2022 case, really the key in all of those cases, or I would say, well, the fact that the adult lives with the child is an important and probably necessary factor for finding that the adult had responsibility for care. Now, simply living with the child under the cases isn't sufficient. The adult must have also assumed the responsibility to provide for the necessities of life. So if you look at Jones, in Jones, he lived with the child victim for 3 months. And the court said he acted as a caregiver to the children and was, in essence, their stepfather, although not married to their mother. And then if you look at Swanson, which is the first in that trilogy, and this court approved the analysis in Swanson of the definition of the word care. And in that case, Jones was convicted of DUI and 2 counts of child abuse because he had 2 kids riding in the back of his car as passengers in the car. And the court said, one of them was the child of his girlfriend, also a passenger in the car with whom he was living at the time of the arrest. The other child was a friend of the child. And the court noted there was no evidence of the defendant there having supplied either child with food, shelter, medical needs, discipline, supervision, or the like. So under Swanson, again, which the court approved in Jones, having control of the car where the children were riding, that's not enough for care, and nor is simply living with the child. And Smith actually picks up on that quite a bit. There's a good analysis in Smith, which again, this court approved in Jones on the definition of care. And in Smith, the defendant was living with the child victim and her mother for a few months. And the court notes, Smith treated her as his daughter almost from the beginning. He referred to her as her daughter, and he controlled the mother and the child. And so he did have care in that case because he voluntarily assumed the role of primary caregiver in that case. And then in the Samantha Allen prosecution, the defendant in that case was living with the child victim for about a year when the child died. And in that case, the defendant admitted that she was involved with the child's discipline, care, and education. And so Jones and these related cases tell us that a person with custody and control of a child has the responsibility for their care. And there's rights and responsibilities that go along with that. And that's providing those basic necessities of life. And in fact, if you look at the mandatory reporter statute itself, the legislature refers to those concepts together. And so I'd like to point you to subsections A and F of the mandatory reporter statute. And what the statute says that in the instance where a report is going to be made about a person who does not have care, custody, or control of the minor, those reports are made to a peace officer only, not to DCS. So the legislature is treating those concepts together. And you can see that in subsection C in the statute, where it refers to when a treatment professional receives a statement from a person other than a parent, step-parent, guardian, or custodian in the course of providing sex offender treatment. And also, I think subsection D1 of the statute is very interesting for this purpose to show that this is one concept, care, custody, and control of the child. Subsection D tells mandatory reporters what they have to report when they make a report, and that section requires the report to include information about the child's parents or the person or persons having custody of the minor. Now, that's just in the mandatory reporter statute itself. There are numerous statutes throughout the code that, again, make clear that these words, care, custody, and control, refer to the same thing. It's someone who has custody of the child and providing for their necessities of life. Just a couple of examples to look at them. 133623, care or custody, is the child abuse statute that's being addressed in Jones in those cases. I would also urge the court to look at 8201, which is definitions, and the mandatory reporter statute refers to 8201. So you see in the definitions there of abuse, neglect, neglected child, again, the legislature treating these concepts as one concept.
Does it make a difference that, I mean, you cite, I think, probably the language care, custody, and control is all over the ARS, I mean, in multiple respects, but it's not actually in this statute, it's simply care. So there is no custody control element. So I'm having some difficulty in, while understanding the argument that subsection A5 can only refer back to A3 and like scenarios, I don't really see that from the text. And certainly, and we have lots of cases on school torts that talk about in loco parentis and the care obligation and that kind of thing school folks are supposed to give. So maybe could you drill down a bit about why it doesn't matter that they didn't use the word custody or control?
Yes, so thank you for that question. That phrase has responsibility for the care or treatment of the minor. Just to give you a little history on that, okay? So I urge you to look at the 2003 restyling of the statute because you'll see that's when the current style of the statute was put into place. Previously, you had language that said, and it was all of the mandatory reporters were lumped together all in one section, subsection A, and it said, and any other person who has responsibility for the care or treatment of children. That's pre-2003. And then in 2003, it changed to break out all of those subsections of the statute. Now, as far as I could go back in Westlaw, which I think was 1989, that language has another person who has responsibility for the care and treatment of the children was in there. And that just got moved to subsection A5 as it is now. And what I will tell you, Chief Justice Timmer, is that my explanation for why responsibility for the care or treatment of minor does not include custody is one, care means custody. So the legislature knows that per Jones and the dictionary and other definitions. But I really just think it's a grammatical construct because the legislature was trying to indicate other people who responsible for the care or treatment, and just using the word custody doesn't fit in there in the same grammatical construction.
Counsel, let me follow up on that though, and we've been talking about the purpose of other statutes that were analyzed in the trilogy of cases that you're mentioning. I'm wondering, why can't we read the mandatory reporter statute as broadly as it might be read, in that when it comes to A5, it really means anybody who might have had care of the child. That yes, there is a criminal provision to this, and I understand the vagueness or overbreadth argument, but why can't we read this to say, well, the legislature wanted anybody who might have had the opportunity to observe abuse, report it? Couldn't that also be consistent?
So, no, Justice Montgomery. I'll say, yes, this is a criminal statute, and you need to construe it strictly according to the words that the legislature used. And the legislature used the word care, and it has that specific meaning when it uses it. And I'll just point out that the criminal considerations here are primary. This is a criminal statute. Arizona is one of the few places that punish a failure to make a mandatory report with felony punishment. And as this court recently said in the Gordon Owens case, criminal statutes must give fair warning of the conduct prescribed. Now that's a statutory requirement in Arizona. It's also a constitutional due process requirement. And I think this is really important because 13104 says fair warning of the conduct prescribed. Now this statute is different. This statute doesn't prescribe conduct. This statute subjects a person for criminal liability for failing to do something. It puts an affirmative obligation to act on someone. And so, especially in that situation, people do need very clear notice that they are covered by the statute, they are required to do something, and what they're required to do or suffer criminal penalties. And so that's why the court should hold consistent with Jones in that trilogy that has responsibility for care means a person who's a de facto parent. Now, the Court of Appeals didn't read that word care right out of the statute. And I do just want to address, Justice Montgomery, that there is a policy, a public policy behind the statute of protecting children. And that's clear. However, the legislature balances multiple public policies when it's drafting statutes. And actually, the court said in Avicia that a public policy here is we want to avoid a broad reading of the statute because it could create an unintended incentive for people to reflexively report things to law enforcement. And actually, in this case, when we're talking about people who help out with children or spend time with children, reading this broadly could also have the unintended effect of discouraging people from doing that.
Why do we not? The duty of care is obviously an established principle under Arizona law for tort duties and such. Why don't we read care consistently with that well-established legal principle of the duty of care?
Yes, thanks, Justice King. I would just note that this falls, the court has said many times, you need a special relationship or a duty created by public policy in order to impose tort liability on a person to protect another person from harm against another person. And so this falls in the public policy prong under the mandatory reporter statute like in Avicia. And so in order to find a tort duty in this case, there must be a duty under the mandatory reporter statute A5, and there is not one here. I'll save the rest for rebuttal if no other questions. Thanks.
Thank you. Mr. Trebon?
Thank you. It's me again, John Trebon, on behalf of the Doe minor children, here with Lynn Cadigan, co-counsel. Care is not custody. Care has been clearly defined in Jones. And I almost get the idea that you can't have a general construction of a statute after listening to Ms. Brody. So maybe the legislature did it wrong. They should have said grandparents, because otherwise grandparents aren't covered, right? And if they said grandma, they should say grandpa, shouldn't they? And if they say grandpa and grandma, what if grandma marries a new guy? Should they say step grandfather? Should they say aunt? Oh yeah, we should include aunts, right? What about first cousins? Should the legislature say first cousins? Well, sure, first cousins should be there. What about second cousins? Well, maybe not second cousins, but what if the second cousin lived in the same household in the blended family? Shouldn't we include second cousins then? Yeah, they should say second cousins if they live with the same family. What about uncles? I mean, I'm exhausted. Can't the legislature create a general category with a sensible common denominator and have that apply, oh, maybe that won't pass judicial scrutiny. What
Why
if they
would-
do one more
If
thing?
it's just any other person has responsibility for care, you say care has a broad term, then why list anyone specifically? Why list school personnel, for example, who it's pretty well established that they have care when you go to school, that they transfer care from the parent to the school. Certainly parents have care. It's all kinds of people that have care, but they list different categories. Why do they go to that trouble rather than simply saying everyone who cares for a child and has this responsibility?
Because they had Ms. Brody's reluctance in mind. They wanted to have some nexus of a relationship with the child, and that is care. And what they did is, they did it carefully. They hitched it to this court's definition of care in Jones. And just think of what Jones is, by the way. You look at Jones in 1997, a unanimous decision from this court. You look at State versus Samantha Allen, another unanimous decision from this court in 2022. And both of those cases use the definition of care that we've adopted here from Jones, which is temporary charge of a child and voluntary responsibility of a child in some manner. And those not only served as a predicate for a class 6 or a misdemeanor, they served as a predicate for child abuse, which is all the way from a class 2 to a class 6. And if it's 3623A1, it's a predicate for felony murder. And it was in both of those cases.
Let me ask you the same question I kind of asked in the first case of, well, what confines some of this? This is a criminal statute that needs to give fair notice to people of what they're required to do to make this reporting. So how is the neighbor who gives kids rides to school every day, carpooling, or the teenager who babysits, or people that just, stop in and have that very temporary control and custody of a child to look after them, how are they supposed to be placed on notice that they fall under this statute? Is there anything that cabins some of this?
Well, I can't imagine a statute that's received more notice. The Attorney General's written opinion, the prosecuting attorneys have written a pamphlet on it, schools have written pamphlets about it, churches have written pamphlets about it. I mean, the word is out there more than probably any other statute.
Well, and so, I'm glad you brought that up. I mean, looking at these categories, I agree with you that several of them certainly are people who have gotten training on just what you said: school personnel, sexual assault victim advocates, domestic violence victim advocates, doctors, etc. What about the teenage girl in the neighborhood? How does she get noticed that goes over and babysits on a Friday night?
Well, she has noticed if she had care of the child. I mean, first of all, of course, we know this statute is meant to give a voice to defenseless children. So people that are in some position of responsibility, and yes, they could have said any person. There's one state that has done that. So they're saying some sense of responsibility. And so if you have care of a child and the child knows you well enough to disclose physical or sexual abuse, you have a responsibility to report.
Well, it's not only just disclosing, is it? I mean, I suppose that if you suspect abuse by you see a child covered in bruises or a black eye, then they don't say anything. In fact, maybe they say, no, nothing happened. I tripped and fell, but you suspect no. Aren't they required to report?
Well, if they had responsibility for the care of the child in some manner, that's the exact language from Jones, yes. And why shouldn't they?
Well, but counsel, you're almost assuming the conclusion and saying that because you babysat someone, you had care, therefore you have a duty to report. But that, again, is presuming that when it comes to fair notice, that every 13-year-old girl who goes to babysit the neighbor's children, by definition then, knows that they're supposed to report if they get any information about physical abuse.
Well, I think 2 points there. Number one, I do believe it's the legislature's prerogative to decide standards of care. And it's not, I mean, the words in your later statute, in your recent cases are, unless it leads to an absurd or unconstitutional result, we uphold.
You don't think it's a bit absurd to assume that every 13-year-old girl who goes to babysit on a Friday night then must know that she has a duty to report any abuse she might observe?
Well, it's not our case, obviously.
No, it's not, but when we write this opinion, we may very well write it to cover that case. And that, obviously, that's our, you can see that that's our concern. How do we interpret A5 in such a way that encompasses what the legislature wants, but not so much that we sweep in, and I'll use the example again, that 13-year-old girl who got invited by her neighbor to come over and watch her kids for 3 hours on a Friday night, so let's make it even more sympathetic, to go Christmas shopping.
Well, maybe you carve out an exception for minors, and maybe that should be separately briefed. I
So
think-
now we're writing a statute.
Well, I'm just saying, you'd have to decide a minor case when you have a minor case. We don't here. And I do think, though, that education is important, and standards of decency is within the prerogative of the legislature. So if the legislature decides that anyone has care, includes a 13-year-old girl, then so be it. What's wrong with that? What's wrong with the legislature making that declaration?
I think what's wrong with it is making a 13-year-old girl a felony when she had no idea she had any responsibility. Shouldn't
Well-
we be mindful of that as we're looking at how, again, and I understand, that's not the case here.
Right.
It may be on the opposite end of the spectrum, but we still have to interpret this and write it in a way that gives guidance so when that 13-year-old case comes up, a court knows what to do with it.
Well, obviously, you can reserve, if you believe that a minor shouldn't be subject to the statute or it's not clear, wait until that's briefed. But let me give you an example. Let's say Mr. and Mrs. Jones are going to church, and it's going to be a elongated church proceeding. So they drop off little Sarah at the Sunday school teacher and say, hey, Sarah, Miss Smith is going to take care of you. She's going to take care of you for the next couple hours. She has charge of you. You be good. And the Sunday school teacher says, hey, no problem. Sarah's a good little girl. I'll take good care of her. And that would be, you interpret statutes within common parlance. Isn't that language accurately describe both care and temporary charge? And that's what Smith requires, that there be care of a child and temporary voluntary charge.
Well, and to get to the outlier notice issues, there is not a constitutional challenge or an as-applied constitutional challenge here as yet, correct?
And of course, thank you, Justice Bullock, you're correct. And how could there be? How could there be? I mean, there's been more notice about this statute than any other.
When you say A5, any other person, and so you were saying that, who is Ms. War like? Is it like the parent category, or is it like the school personnel category or another category?
You know, that's a good point. Let me start by saying, I think there's a mistake in the way the case has been represented to you. In Jones, the Livermore opinion in Swanson was, the reasoning of that case was disapproved in Jones. That's where Judge Joe Livermore, I think, described custody. He used the word custody from Title VIII. In Jones, you expressly said we don't look at the definitions in Title VIII for this statute. Number one. Number two, they said we agree with the result in Swanson, but we don't agree with the reasoning in Swanson. They agreed with the reasoning in Smith from Division II, but not with Swanson. So the language about custody in Swanson was directly disapproved. Okay? And I'm sorry, what was your question?
I'm kind of waiting to get back to answer my question. So if you're saying any other person, you're saying that Ms. War is any other person under A5, who is she like in your view? Is she like school personnel, or is she like a parent? Who is she like?
She's like any other person who had care of the child. So she voluntarily accepted responsibility for the child in some manner and had temporary charge of them, and that is providing care under Jones.
Okay, so that would be as a Sunday school teacher, though, right? Because that is something I wanted to ask you to clarify. I know she babysat, but in the Court of Appeals, in a footnote, it said that you didn't raise that and that was waived. Is that so about the status of the babysitter?
Yes, we're relying primarily on her being a Sunday school teacher, not a babysitter. But she babysat a few times. But it's obvious that in the course of her being a Sunday school teacher, and by the way, this isn't a one-time thing. She had the children 6 years every Sunday for 2 hours, say 5. That's 307 Sundays. That's over 600 hours. So this case should be easy. If you want to do it by a case-by-case basis, Justice Montgomery, this case should be easy. She had the children for over 600 hours. And she obviously accepted temporary care in charge of the children during that period of time. In fact, she says, I knew them intimately. I knew them better than anyone else.
Does
So
the
let me
record-
follow up on that. Let's say we agree with you and the case proceeds. There's still a big modicum of proof that she actually did observe or was aware. It's not like a strict liability. We're going to impute that knowledge. There seemed to be some confusion in the briefs as to that point. So I would appreciate if you would clarify that.
That's true. It's a factual question. It's a jury question. And that's what you said in Jones too. These are jury questions to be decided in each case. So yes, that is, we're not asking you to issue summary judgment in our favor now. I think you could probably, in the fact that her 307 Sundays is enough, but whether or not the rest of the factual predicate has been proven is obviously a jury determination.
Is there anything in the record, though, that reflects that she developed this information or knowledge in the course of her role as the Sunday school teacher?
There is. She said, you know, as soon as the children came in, I could tell when Paul was at home because they acted so differently. They wouldn't look at me. They wouldn't look at each other. They would only look down. And as someone who has a degree in psychology, I knew that what I was seeing was abnormal. And she uses, not me, she uses the word abuse. I knew that there was abuse going on in some manner because of how I observed them. I've been a women's basketball teacher. I've traveled the world. I know things. That's what she said. And I knew that there was something wrong with these children. Now, of course, later she says, well, I didn't know exactly what was wrong. So yes, is it a jury question as to whether or not she had a reasonable belief? Yes, it is. And we're prepared to try it. But yes, that's a factual determination exclusively for the jury. No question about it. So,
You know, following up on that, maybe it's a little far afield from this case, but it makes me wonder, what type of evidence does a plaintiff have to come forward with to say that while she was at the Sunday school teacher, this was evident to her, or should have been, because unfortunately there's a lot of parents out there that aren't the best parents, and their kids are maybe depressed or anxious or whatnot. And what you just said puts me a little bit uneasy to think, well, then every time that a Sunday school teacher sees an upset child, anxious child week to week, that means that they should be reporting, or at least there's a question of fact that they can be sued for that?
well, we know if you report, you get immunity under J of the statute. But if you have a reasonable belief of abuse, that's a factual determination. We're not asking you to make that. But that would be the judgment of each individual person, but it has to be objectively reasonable. So if you have a reasonable belief that a kid has been abused, you report it. And as Ludwig and Ramsey and all the other lower court cases say, it's a low standard. You should report. What's wrong with the legislature making a public policy that, yes, we encourage you to report. We'll give you immunity when you do, but we encourage reporting if there's a real suspicion or reasonable belief of abuse. Here there definitely was, but of course we have to prove that.
Well, we did say in Avisha that we don't want, well, not we don't want, that we didn't read the law as saying that people should just be constantly reporting any kind of suspicion. So I think that was what was driving my question.
Well, look at their brief. They did the factual data analysis. And what they found is in the last 23 years, there's been 2 cases that have been prosecuted under A5. And both of those involved parents who were babysitting and saw their own kids molest other kids in their presence. Nobody else has been prosecuted. So this whole argument that there's unsuspecting people that are going to be prosecuted, well, it's never happened. And who are these unsuspecting people? I'd say the indifferent, the sadistic, and the morally depraved. So if you have a reasonable belief of abuse, report it. That's what the statute's saying. And I submit to you, it's exactly what the legislature has the prerogative to do. They have the prerogative to say, our public policy is, let's report suspected abuse when you see it.
Counsel, I'm wondering, when we look at the fact that the term care requires that the person accept responsibility for the child in some manner, is that acceptance of responsibility a matter of degree in any way? In other words, are we looking at what exactly they're accepting to be responsible for? So a teacher perhaps is responsible for taking care of that child during all of the hours that the student is in the classroom. Someone in a church setting may agree to make sure that the child doesn't hurt him or herself, that doesn't put a peanut up their nose or do basic things like that. That happens a lot, apparently. Is there some concern for what exactly the provider is accepting responsibility for?
They're accepting responsibility for the care of the child in some manner. I mean, that's been good enough for felony
Right, but
murder.
a step parent accepts responsibility for providing food, shelter, guidance, morals, all of that. A Sunday school teacher doesn't accept all of those responsibilities, only to make sure that they're alive and healthy when the parent gets out of church services, right? So do we take into account the degree of responsibility that the caretaker is accepting in determining whether they're mandatory reporters?
First of all, you don't. That's a jury question. It's reviewed for sufficiency evidence, and that was true in Jones, and it was true in the 22 case as well. So, by the way, if in Jones, the way I read it, if you went back and looked at it closely, not only was they living together supposedly for 3 months, the opinion, as I read it, also says he took the girl out, the little 4-year-old, out 3 times that day on his own. The court clearly implies that's sufficient for care. Him taking her out 3 times in his vehicle and getting ice for her at Circle K and telling someone, somebody else said there's something wrong with her, and he says, well, I took her to the fire department, the paramedics looked at her. That was sufficient for care in Jones, and he got the death penalty for it. So it was not only good enough for care under 3623, it was good enough for felony murder and the death penalty as well. But it's a jury question. So the jury looks at it, determines whether or not there was responsibility for care. But if you're alone with the child for 2 hours every Sunday for 307 Sundays, you're accepting responsibility for care of a child. And like in the Samantha cases, the 2022 case, they say, well, they were living together. There were 24 people living in the house. So she was only one person of 24 that was in the house, but she's the person that put her in the box. They put her in a box and closed the lid as a disciplinary matter. That was enough for care. And again, the court didn't determine that's enough for care. They said there was sufficient evidence in front of the jury for that factual determination to go to them, and we uphold it. The jury could come to that logical conclusion. So yes, isn't that what our jury system is in this country? They're the moral fiber of our laws, and they determine these factual determinations based upon the wording of the statute is given to them in a jury instruction. That's what juries do in this country, don't they? What's wrong with the legislature doing that?
Mr.
If they
Tribon, if
don't-
you could give a wrap up, you're beyond your time.
If they don't do that, you're going back to the listing thing. They could never win. And they hitched it to Jones. They hitched their definition of care to Jones. It should be good enough. It's good enough for 3623. It should be good enough for 3620. Thank you.
Thank you. Ms. Brody.
Thank you. Just a few points. First, I would say courts decide tort duty as a matter of law at the summary judgment phase based on the undisputed material facts. not juries. And so the undisputed material facts here that are relevant to whether Ms. War had the responsibility for care of the minor, the plaintiffs in this case, is that she never cared for them overnight. She never provided them with food, shelter, medical care, or the type of supervision that the legislature meant when it said the word care in the statute. Now, care isn't, it's a bright line. It is a person who has accepted that responsibility to provide for the necessities of life: food, shelter, medical care, and clothing. It's not by aggregation how many hours a person spends with a child over time. It is a bright line. It is a person who is acting as a de facto parent. And Chief Justice Timmer, I do want to address your questions about the school context, and go back to Justice King's question about a school can be liable for a third party's harm to a plaintiff based on the special relationship, as the court discussed in Dinsmore. That's a special relationship, a tort duty created by special relationship. It's similar to the duty that goes to a parent to protect the child, right? That is something that comes along with being a parent to a child. You protect the child from harm. You protect them from harm from other people. Step-parent as well. Custodian, legal custodian as well. That's what a person who has responsibility for the care of the minor has to do. They need to protect them from harm.
Returning, and I realize the time is low, to Justice King's question, if a babysitter commits an act of negligence harming a child, is the person immune from tort liability?
Well, a babysitter who harms a child may be responsible for their own negligence, but they're not necessarily responsible to protect that person from harm against other people, including harm by the child's own parents.
But the
And so
care is the same element, is it not?
It's
The duty
not.
of care?
And so to address that babysitter or temporary caretaker, temporary person for responsibility, that's not a person who's voluntarily assumed the role to care for the child and all those needs. That's a person who has been delegated limited authority of responsibility by the child's parents. When I leave my child with a babysitter, I don't expect that they're gonna do everything. I expect they're gonna do what I tell them to do. That's a delegation from me to them that's temporary. That accepting responsibility for the necessities of life is that structural relationship that the legislature means by care. And I would urge the court to affirm summary judgment.
Thank you. Thank you, Ms. Brody. Thank you, all counsel, for, as I said in the first case, for your briefing and an excellent oral argument today. We'll take the matter under advisement and issue an opinion in due course. All right, and so we stand technically adjourned there, but we're remaining on the bench for, and counsel, you may stay or leave, as I said before. You're welcome to stay or leave. Maybe someone would have questions for you, but we will not be discussing either case. And thank you again for taking the opportunity and time to come down. Okay. Now I wasn't saying you should murmur because we have a second part here, and that is to
Go ahead, push on.
okay. For those of you staying, if I could have quiet in the room, please. We are here to allow you to the opportunity to ask some questions of the court. But what I first want to do, okay, I've lost control. I need the gavel. Thank you. Thank you. Okay. That really does work. I need to get one of those. I actually have about 6 of them, but I've never used it. All right. I want to thank all of you here in attendance today for attending both oral arguments. It's a wonderful time for the court to come back to where we go to both schools every year, and we really enjoy it, taking it on the road. Before I forget to do it, because I've written this down for me to make sure I don't, is I wanted to thank all the students, but I want to thank everybody who made this possible, because there's a lot of people both at ASU and with our court, from IT to security to the clerks that we have here running it and beyond. Thank you very much for having us here. I want to thank Dean Stacy Leeds, even though she's leaving and I'm bitter about it. I still will thank her for having us here as well, and everybody else at the college who helped. And I think I've got everything. Oh, and our AV department too, I forgot that. So, and our communications team, thanks to everybody for putting this on. It really does take an effort. All we do is just get in the van and come down the street, and it seems easy peasy, but it takes a lot of work. So it's important to us to have these kinds of opportunities, as I said, because we've reached an interesting time in our lives. It's always an interesting time to see what people view our government institutions, which includes our courts, and how they view us, and the faith that they have in us is very important. As I think it was probably Alexander Hamilton who had said that the executive branch has the sword, the legislative has the purse. All we have is the faith of people. And this court, I can tell you, feels very strongly that to have the faith of the people need to know what they have. And they need to know it, and they need to value it. And to know it and value it, they need to see it. And so this is part of our effort to get out. And frankly, you as future lawyers and officers of the court, we're depending on you to describe to your friends, to your neighbors, to everybody else, even when you disagree with a case and think it's just hogwash. Nevertheless, instead of attacking maybe the individual judge or such, educate folks on what the court is and is not. We're not a second legislature. We don't just do what we think is best in the world, if only. Wouldn't that be fun? But we don't. We swear to uphold the Constitution of the United States and the Constitution laws of the state of Arizona, and that's what we endeavor to do at all times. So that's kind of a heavy-handed introduction. But what we want to do is answer your questions. So we have, I think, do we not, Alberto, microphones? Yes, there's Alberto, who's our wonderful PIO. So please ask any question, as I said, as long as it's not about either of the cases that we just heard today, we're happy to answer. So either these are the first brave people
Alberto
or
has asked
people
if you
trying to
can
leave
come down
quickly.
if you have a question.
If
He
you have a
doesn't want to
question,
get
if
his
you could come
steps
down,
in.
that'd be helpful.
And I will warn you, if there's no questions, we'll just talk.
If you have a question, you can line up.
Hello, Justices. Thank you so much for coming to speak. My name is Troy Evans. I'm a 1L here at ASU. My question is, when you're reading briefs and you're getting prepared for oral arguments and days like this, how do you pick the questions you're going to ask? Do you have some pre-written down as you're reading the briefs, or is a lot of it, do you come up with them when you're here in oral arguments, listening to the attorneys give their arguments? Thank you.
That's a great question. And the wonderful thing about I didn't introduce myself, it just occurred to me. I'm Chief Justice Ann Timmer. I have been the Chief Justice since 2024. I've been on the Supreme Court since 2012. Before that, for 12 years, I was on our Court of Appeals, Intermediate Court of Appeals. And before that, I was in private practice with firms here in Phoenix. Wonderful to be the Chief Justice. Number one reason is I get to delegate things like this. So I want to delegate that question to Vice Chief Justice John Lopez and introduce him. So Justice Lopez has been on the court since 2019. I know it's 17. Darn it, I know we did rehearse it. I thought I could memorize this. But Justice Lopez went to, I forgot to say, I went to ASU Law School. Yay, go Devils. With Justice Lopez also went to ASU's law school. I know, I'm waiting to see if you guys clap for the U of A people, but anyway, Justice Lopez came from the ranks of, he was our Solicitor General in the state. He was with the U.S. Attorney's Office for many years, and I think a little bit in private practice before that. So please answer the question.
That's a great question, and I think as you read through all the materials, read through the briefs, there may be certain sort of foundational questions or clarifications that you want to elicit from the parties. But during the course of oral argument, conversation may go ways that you hadn't anticipated. Parties may make statements, may make their own clarifications or concessions on particular points, which raise new issues or refine the general topics that you wanted to ask the parties about. But I think everybody probably has the same general approach in that regard. But like like any game, any experience in life, you know, you have a plan, and then, you know, when first shots are fired or first ball is thrown, then things may evolve in unanticipated ways.
Hello. Okay. Question kind of for Chief Justice Timmer and Justice Montgomery. You both mentioned that when you're making a case like this, you're considering how this will affect other cases. You want to provide guidance to other judges. Do you think there is a conflict between kind of projecting this across the state and maybe just, you know, in a case like this that is, you know, almost a statutory interpretation? Do you think there's a conflict between getting the statute interpreted correctly and also interpreting it in a way that accounts for everything? If there is a conflict, how do you kind of approach that?
And I will let Justice Montgomery answer most of that, but I'll tell you there's an adage out there among courts and such that generally the Court of Appeals, the court that I came from, is an error-correcting court, and the Supreme Court is not, because we have discretionary review, so we really are more cognizant of the fact that when we interpret statutes and such, that it will be the precedent for the foreseeable future, at least for long term. So that is always in our mind. It's in the Court of Appeals as well, but I think even more so on the Supreme Court than at the Court of Appeals. Now, Justice Montgomery might have a different take. Sometimes he and I don't agree on everything, hard to believe. Justice Montgomery came to us in 2019. He also is an ASU graduate from law school.
3 in a row.
A triple double. And he teaches here as well. So you probably have seen him wandering the halls a bit. So direct him where he's going if you see him wandering the halls. And before that, he was our elected county attorney in Maricopa County. And I think his whole career has been his legal career in criminal prosecution. And before that, he was an esteemed member of our armed services. What branch was that again? The Marines, the Navy,
Since you know that.
I know the answer.
I served in the Army for 6.5 years. Given the hint that I might have some cognitive difficulties, I guess you're applauding that I know the amount of time I served. So to answer the question directly, and not with any reference to the 2 cases we heard this morning, I would say that, and I agree generally with the chief, that, you know, when we're addressing issues and resolving, particularly cases involving statutory interpretation, we're mindful that when we resolve the case, we're obviously answering the question that the parties presented to us, but we're also looking to make sure that we're interpreting that statute in a way that's going to provide guidance to future litigants. We want people to understand how their law works. And ideally, when we issue an opinion, there sort of is those 3 levels of audiences that we're looking at. We want to resolve the issue that's presented by the litigants before us. We want to provide guidance to future litigants and courts. And we also want to be able to communicate to the people of Arizona that this is how your law works. So if there's something people don't like about a result, they know where to go to fix it. You know, you don't get mad at us. You go talk to the people who write the laws in the first place.
Hi, I'm Alex Lambert. My question's about, legal skill building, I guess. I noticed in oral arguments today a lot of keeping ideas distinct and tight. And Justice Montgomery, you talked a lot about making sure we're not conflating ideas. I'm just curious how you have felt like you have built that skill over the course of your legal career, and specific things that maybe you've done to build it well.
Well, that's an interesting and excellent question. Now, I'll ask Justice Bullock to address that. Justice Bullock came to us in 2016. So he and I were the only vestiges when this court was 5 people. So it's just the 2 of us left on that until the court expansion in 2017. He's our outlier, so you can still clap, but he went to UC Davis for law school. And before that, had a career with, what would you call that? With public interest litigation, esteemed career there. So Justice Bullock.
Well, and also a teacher here, and I highly recommend my Survey of Individual Rights course. So if the first case, the constitutional aspects floated your boat. That is one of the many areas that we cover in what used to be constitutional law too, and is now called Survey of Individual Rights. So I was an appellate advocate for all of my career until joining the court. And in terms of skill building, oral advocacy was by far my weakest skill. And so I had to really devote a tremendous amount of work to it. And I started in law school, mainly by doing moot court, because you want to get your mistakes out as quickly as you possibly can when they don't matter. And so those of you who are interested in advocacy, I strongly encourage you to do that. And then really just practicing and moot courting for every argument. The most skillful advocates in our country still moot court before arguments. You never get to the point where you can just walk in and, and take it on. Another thing that I did that not all appellate advocates do is that I would always try the cases that I would later argue in appeal. And there's, especially in larger law firms, there's often a bifurcation between the trial arena and the appellate arena. I felt that being the trial lawyer had two advantages. First of all, I built the record the way I wanted to argue it on appeal, and I knew the record when I argued on appeal. And a lot of cases really turn on the record. And I can't tell you the number of times we have lawyers come in and say, "Oh, I wasn't the trial lawyer." Guess what? You still get to answer that question. And so those are the sorts of things, just practice, practice, practice. Never take an argument for granted. And as best you can, if you didn't create the record yourself, immerse yourself in it to the point where someone can ask you a cold question about an odd detail in the case, and you know exactly where it is in the record. It's not easy. Once you get up here and you have your 20 minutes and 7 people are firing questions at you, that is definitely not the time to be conceptualizing your case for the first time. So those are just some tidbits that have helped me out.
Yeah. I'm going to add to that a little bit. Because not everybody has the luxury of public interest with a client that you can do moot court and all of these kinds of things. Many times I was more of a trial attorney than an appellate, but you don't have the luxury of a lot of time. You have a client with this much money. And so you don't get to do immersion. You really need to look for ways in your career to be as efficient as possible within the economic confines that you're dealt with. So sometimes it's great, man, it's great if you can moot court something. Other times, frankly, I would spend the time just thinking it through myself, walking around listening to Bon Jovi. And that was my preparation, and all I could afford to make sure I have it down. But get used to making sure you connect those dots. Don't just jump to your conclusion. You need to build it and you need to show it, and get used to thinking that way. As I tell my law clerks all the time, if you can't connect it, it might not be the right answer. So you got to figure out a way. Which reminds me, I wanted to introduce those law clerks. So if you could all just stand up, that would be great. Please. They are wonderful. All of them, I think most of them are from U of A this year. Every year it's a little different, but they're great. They're wonderful for us, and they do help us on not only research and things, but a lot of that thinking through what if, how did it change, that kind of thing, and really honing that kind of practice you were asking about, of getting that compartmentalization and then viewing how the whole thing puts together. So thank you all for your work. Next question.
Good morning, Justices. Thank you all for being here. My name is Rajat Arora. My question actually kind of builds off of Justice Bullock, your last answer. So for the vast majority of judges and justices, you start off in litigation and you are essentially a zealous advocate. And you kind of have to, for more or less you're given a case and you get accepted or not, but you start from the end point of who you want to win, and then you build your argument around that. And you live your life as an advocate, and you are obviously, or at some point, very effective advocates. You're not necessarily that as a judge or a justice. How do you, and I assume that when you see bad lawyering, you probably think that like, oh, I would answer this differently. How do you take that litigator hat off, that advocate hat off, and don't presuppose the answer and then build it from the back, but actually analyze the arguments as they're presented to you?
Okay, I'm going to let Justice Bean answer this. This is Justice James Bean, Jim Bean. Jim came from U of A. He's a U of A law graduate.
Very good.
And came to us in 2019 as well. Before that, your entire practice was in criminal law, I believe, right? Criminal prosecution. So, Justice Bean?
Excellent question. Part of my bio too, I served as a trial court judge here in Maricopa County as the Superior Court. I was on the Arizona Court of Appeals for Division I here in Phoenix, and then time on the last 7 years on the Supreme Court. So, and as the chief mentioned, I was a prosecutor predominantly for my time as a lawyer. So I was an advocate. About half time was spent in the trial courtroom, and half time as an appellate lawyer for the Attorney General's office arguing criminal cases and capital litigation. So when I first was appointed to the Superior Court, I went obviously from an advocate to a judge, and that's where I really saw what you were describing, sir. I saw advocacy that wasn't the best, let's just say, and it was really tough for me to kind of hold myself back and not, aren't you going to object? Aren't you going to, do something, because you're really not lawyering your case the way that I would have had I been in their shoes. So it was nice that I got to kind of ease into that role as a trial court judge, and my first rotation was on the family court bench. So I got to temper that desire to lawyer the cases in that setting. It was something I had to deal with. It was something obviously I overcome with time. So what you do is, what I eventually came to realize was, I'm no longer an advocate. Obviously, I'm here as a neutral arbiter to take the law that's presented in the case that the parties are presenting to me and hear their argument, and then apply the facts to the law before me, and just kind of let it unfold. Rarely, or if I tried very hard never to have a predisposition in hearing a case like, I served in the family court, I served in juvenile court, I did work in the trial bench as well as a criminal trial judge as well. And you just kind of let the cases come to you as they come, and tamp down the ability or the desire to lawyer the case. And that took a little bit of time, but again, you have to switch roles, switch hats, so to speak, and realize that what your role is as a judge, and you're not there obviously to advocate. You're not there to say, well, if I was king for a day, this is how this should come out. You let the law obviously speak to you, and there are a number of times. Especially when I was an appellate judge on the Court of Appeals and on this court, that I'm like, well, I really would like to see the result come out this way. But after you do a deep dive in the law and the facts, the law just takes you based on the text of either the statute or the constitutional provision. It's going to take you another way. And you have to be comfortable with, setting aside your personal predilections and your personal desires, and just landing on what the law tells you, given the text, and how you interpret that to give meaning to what the legislature meant in passing that law or passing that constitutional provision. So it's a process. It takes a while, but it's just enmeshing yourself in your new role as a judge and leaving the advocacy behind. But thank you for that question.
So my name is Savannah Benson, and my question is a little bit more procedural. My understanding is that the Arizona Supreme Court recently changed some of the procedures to allow advocates to speak for about a minute to a minute and a half before asking questions in accordance with the U.S. Supreme Court rules. And I was wondering how those rules come to be and whether you usually try to follow the U.S. procedures or if it's based more on the procedures of the state court.
That's a great question. I'm going to ask Justice Catherine King to answer that. Justice King is also a graduate from the University of Arizona College of Law. She has been in the court since 2021, right? Okay. And her practice beforehand was private practice mostly in the employment area, private practice here in Phoenix, but she did a stint with the governors at the time, Governor's Council as well. So, Justice King?
Yeah, thank you for that great question. And obviously, you've done your research. So to begin, one part of your question, we do not rely on what the U.S. Supreme Court does, or, it is not something as though our federal rule, whatever the federal rules of civil procedure are, we are going to be in lockstep with them. So just to start out with that principle as well. So typically with our rules, we have a very formal rule process, which is somebody can file a rule petition if you would like, any of you. If you see a rule of civil procedure, a rule of criminal procedure, rule of evidence that you think really is just lacks clarity or leads to unintended consequences, you yourself can file a rule petition to change the rules. And then there's a briefing process. It's open for notice and comment period. And then we conference twice a year to decide whether to adopt the rule petition, adopt the rule petition with some modifications possibly, or to deny the rule petition. Now, what you've described is not that formal process. So we recently just started talking internally about we decided informally, let's give this a shot, because as you can see, the lawyers come up and they have a very well prepared outline. They have some of their best arguments, that they want to make at the initiation of the oral argument. And sometimes what happens, just practically speaking, is we may launch in 20 seconds with a question, and therefore the lawyer doesn't even have a chance to get off the best arguments that they made, that they prepared within their outline and spent days probably preparing. So we informally decided to proceed that way, which is just to allow a couple of minutes of the lawyer to present their argument before we would launch into questions. But that was not, just to distinguish it from the formal rulemaking process, we just informally decided to go that route. Thank you for that great question.
I know, and we're all worried up here that we didn't mind that this time. Did we wait? I hope we waited. We did. We waited? Okay.
A minute and a half.
Hi, my name is Elijah Swolgard. Thank you all for being here. Kind of going off of Alex's previous question about skills, we're all in legal advocacy right now and doing oral arguments. What are some good tips for a good oral advocacy versus a bad oral advocacy?
That's a great question. And I'm going to ask Justice Maria Elena Cruz to answer it. Justice Cruz, also a graduate of the University of Arizona College of Law. Like Justice Bean, she's a triple threat. She was on the Yuma County Superior Court as a trial judge, presiding judge down there. And then she came to the Court of Appeals up here and then Supreme Court in 2025, so just last year. But she's already beyond her anniversary date, right? So I told her this morning her Cinderella year is over. So.
Yes, thank you. So that's a good question, and I know we've said that about all the questions, but it is really important that we understand that the presentation that you give as an advocate is just as powerful, or can be just as powerful as the message itself. So some of the things that I have noticed since being an appellate court judge or justice is that sometimes attorneys are so focused on what it is that they want to say that they don't really pay attention to what it is that we are interested in hearing about. And sometimes you'll hear, well, I'm going to get to that in a moment. And attorneys who don't want to answer the question we're asking there because it doesn't fit within their carefully prepared outline. So a good advocate is going to have their prepared outline, how they want to present, but then they're going to be able to pivot, answer the question, and then come back to the flow of what they were talking about. That gives, at least me, greater confidence that you're not hiding anything, that you're trying to be helpful. And I think it's important for the advocate to know, if we're asking about a specific area, that's because that's what's interesting us. That's what we're going to be talking about when we get back to conference the case. It's not the order of your outline, it's the questions that we were asking. So a good advocate is going to be very careful in listening and seeing the trends. And if you noticed, even though we may have pre-prepared questions, there's a lot of piggybacking that happens, right? Where one justice will ask a question and then someone else will say, well, let me follow up on that. And there's this chain that builds. So that should be an alert to you that we are going to be talking about that probably in greater detail, and maybe some of the other areas are not as important in that moment. That's not to say you're going to neglect any other area, because we may be leaning in a way that's not favorable to you, and so you need to hit all of those marks. But do have the ability to pivot and come back. On the more basic, I think it's important to avoid anything that is going to distract from your message. So I often tell people, wear the uniform. Wear the uniform. Don't bring anything to the presentation that detracts or that takes our attention away from the message that you are giving. I think it's important to have others give you feedback, within your firm. Have others see your presentation and tell you how you're coming across. I think it's important to also speak slowly so that we can understand you, speak up, be confident in your message. Obviously, you are going to have already looked at all of the weaknesses in your case, so you should have a pre-planned way to address each of those issues. So when you do hit them, even though they're the areas that are weaker and may make you nervous, be confident as you go into them, and just be in charge of your presentation.
Chief?
Oh, yeah, go ahead.
To that, I was going to add, you had an opportunity to see excellent advocacy today, so you could see some of those principles as relevant today in action. So I hope you took mental notes and go back and think about what you saw today.
Chief, if I can just briefly add to that, Justice Bullock talked about knowing the record and the importance of that, and I could not agree more. But there's another point just a finer point I'd like to put on that is, don't misrepresent the record or fudge the record. We spend a lot of time going through the record, the Court of Appeals, if it went to the Court of Appeals, the trial court record. We have very smart law clerks that are doing the same. So if there's a question about the record and you misrepresent it or shade it or fudge it, we will find out, and that will not reflect well on you in that case and any case going forward before this court. I also like to talk to young law students and young lawyers about their reputation. It's really pretty much all they have going in front of a judge or a jury, especially judges. So that's something else to kind of store away, is know the record and never, ever misrepresent the record.
Okay, and I know we're actually at time, but I want to take the last 4 questions, but we'll maybe do it quickly, just to my colleagues, the two will just maybe quickly answer it. I know it's also class time for a number of you, so don't feel badly if you need to go. And good luck to all of you on your finals coming up. I know that's always a worry. Go ahead.
First, thank you to the justices for being here, and thank you for the advocates as well. If it's all right, I had a question for the advocates very briefly. I was wondering, in your preparation for something like the Arizona Supreme Court or the United States Supreme Court, where you know what the panel will be, versus Federal Court of Appeals, where you don't know the panel until very shortly before your argument, how does the preparation there differ? Are you crafting arguments for specific jurists?
Yeah. Why don't we have one? Yeah, go ahead and stand up and answer.
I think to some extent that you do that. I have had the privilege of arguing before the U.S. Supreme Court. So when I argued there, not like Mr. Clement, he's argued a bunch of times there. But you do know, I don't think you craft your arguments differently, but you get prepared to answer questions a little differently. And for like this panel, obviously, all the recent decisions that were decided by the court in the last 6 months, I read very carefully because it gave a good idea about where the court was going in terms of statutory construction. So I read all the statutory construction cases as much as I could to see how the court was handling those. And the court has a very specific way that they do it. So yes, when I went, I've argued, more than a dozen. I used to be a federal public defender, so I've argued more than a dozen cases before the Ninth Circuit. And then, yes, you get a 3-judge panel. You can do that more specifically there than you can here, if that makes sense.
I'll say quickly, because I know we're close to time, is that I watch very carefully what the judges are saying and doing in their opinions because I want to win. And so if you want to win, you're going to look at who your audience is. And we're lucky to have all the videos and other, the justices make themselves available to us. So, yeah.
Good morning. My name's Finn. I'm a 1L. I know my classmate Elijah, I don't know if he's still here, asked a question about our legal advocacy classes. And I wanted to add on to that. For those of us who've not done moot court and we don't have a lot of experience in public speaking and we might be more or less dreading this oral argument that we have in the next couple of weeks, do you have any tips or pointers or anything that you would recommend for us who, the last thing we want to do is be in front of a panel of 7 of the most powerful people in the state of Arizona? Thank you.
That's a great question. Whoever wants to chime in on that, please do, has a thought on it. All I will say is, since you're only a first year, you've got 2 more years left. Take every opportunity to speak in class in front of your peers, even if you don't know the answer, frankly, even especially if you aren't certain of the answer, because the more you can in my view, I had to stand up in class, but the more that you can think on your feet and answer questions and engage in that, the more comfortable you will be with the process, and that will hold you in good stead when you are in front of a judge, either at the trial level or the appellate level. So anybody else?
I was going to say, and what you can do in preparation too is film yourself and watch yourself speak. And once you get over the embarrassment and the uncomfortable feelings, then you'll be more confident when you actually have to do it for a grade or for a competition. But yeah, if you don't have the opportunity to get real world experience or be on the moot court team, film yourself and watch how you're doing it. And that'll give you some immediate feedback on things that you can do, at least for presentation style.
I would recommend change the framing. So the way you were looking at it, the way you're approaching it. Right now, you had no problem asking us a question, right? Because you knew exactly what you were going to ask, right? And so we're having a discussion. And apparently you're able to speak with other people one-on-one, right? So instead of looking at it as, how am I going to speak in front of the 7 most powerful people in the state? That framing is going to amp up your stress and your nervous system. So bring that down and say, I'm prepared. I know what this case is about. I understand the record. I know the record. I understand the strengths in my case and the weaknesses in my case. Okay, now I'm prepared. Now I'm going to talk to these people who are going to take turns asking me questions about the things that are interesting to them. And when you frame it that way in your mind, then it's not a problem. Then we're just talking, right?
Also participate in as many moots as you can in preparation for your formal moot. Justice Bullock mentioned that there is no better preparation and no better practice to get you over past the anxiety when you actually do it. And if you do it correctly, you have friends that are somewhat merciless, perhaps even sadistic, and they're invested. A good moot will always be more difficult than the real thing.
Hello, my name is Brett Hill. I'm a 1L, and in property this year, we covered the rule against perpetuities and concepts such as like the fertile octogenarian. So my question is, whenever you're crafting your opinions, how do you balance like these bizarre edge cases and make your opinion in a way where you create a rule that's workable both for what the case in front of you is, what will likely be the most common like incident that would happen under your rule, and these bizarre edge cases? How do you create something that's workable under all three?
Anybody up here want to explain the rule against perpetuity?
Wait, I have my clerks write me a memo.
We actually had, in my first year at the Court of Appeals, occasion to ask an attorney what was the rule against perpetuities, and I thought, I bet she never saw that coming. But that really is the struggle, and I'll tell you, being the most recently appointed justice, that's the difference of getting on this court, because every decision that you make affects not only the parties in front of you, but so many more. And so we're constantly looking at not only how we're going to answer this immediate question, but what are going to be the ramifications? What are the rules? What is the rule that's coming out of this decision, and how are parties going to use it? And we try to prevent from saying things that we don't intend, or having interpretations that are not what we mean. So that is the crux and the most difficult part.
Yeah, and that means sometimes that you have to craft the holding in a more narrow way so that you don't hit upon those unintended consequences that Justice Cruz was referring to.
And not to answer your question at all, but just a tidbit. When I was in law school and studying the rule against perpetuities and wondering whatever could be the practical ramification of this, a movie came out called Body Heat. And it is a fantastic movie. And I'm sitting there watching the movie. I'm like, that violates the rule against perpetuities. I'll bet they didn't know that. And it turns out the violation was the core of the movie. And I know that makes it sound incredibly uninteresting. Just take my word for the fact that it's an awesome movie.
Thank y'all. Good morning for being here. And as we close shop, my name is Chibuike Obi, first year student as well. And my question is more so like career-wise. At what point did y'all, whenever the opportunity to sit on the bench became available, at what point did y'all really have to lean into it and be like, you know what, this is what I want to do?
Okay, I think everybody could probably, maybe we can end on that, answering that. I didn't have a clue that I'd be a judge, nor did I ever, when I sat where you were, all I wanted to be was a really good attorney. And I loved the practice of law. It's all I wanted to do. It really wasn't until I was maybe 12 years out, and our Court of Appeals was way behind, a couple years behind, and so they invited members of the community to come in and sit. It was Division S with one full-time judge and 2 lawyers, and you would just hear cases, and you got to write decisions. And from that experience, it actually was, I still didn't think I'd be a judge, but then when openings came up, one of those judges called me up and said, you should think about doing this. You'd be fantastic. And yeah, I'm like, of course I can't do that. But it plants the seed for you then, I think, when somebody says that. And it got me thinking, especially at the time when I was now a partner in a law firm and I have 3 little kids and all of this, for me, that's when I started thinking, boy, this would be a fantastic job, and it has been. So it wasn't for me until I practiced 15 years, I think, and then went on the bench. So others? You always aim for this?
Yeah. Much like the chief, when I was a law student, I thought probably the worst possible job you could have in the legal profession was to be a judge. And I held that for a while. I was a prosecutor and here in Maricopa County, and it was probably after about maybe a couple dozen felony jury trials that I started thinking, well, you know, I'm having a lot of fun as the chief. I loved being a lawyer. And I really had a great time doing it, and I felt passionate about the work I was doing. But after a while, I'm thinking, well, the person that's sitting up there in the black robe, that would be an interesting job as well. And I started thinking about it, and much like the chief, some of the judges on the Superior Court bench said, hey, you've been doing this about 10, 12 years. Why don't you think about maybe applying for one of the openings that's coming up in the future? And at first I was shocked by that, those statements, but I started thinking about it more. I'm like, yeah, I would like to do that. And I had found fairly quick success, and I was appointed to the trial bench in 2009. I'd been a lawyer about 16 years. But it's just something that it kind of evolved for me, and I think it kind of evolved for all of us. I don't know if anybody really gets out of law school saying, I want to be on the state Supreme Court, the U.S. Supreme Court. Maybe, and if you do, Godspeed. I wish you well. But it was more of an evolution for me. The practice of law is fabulous. You really can do a lot of good for your community. But also being a judge is the best job I've ever had as well. So it just kind of came as a process.
Well, now that I'm in movie mode, there's another great movie called Primal Fear. And Richard Gere's lawyer character is asked if he wants to be a judge one day. And he said, why would I want to be an umpire when I can play ball? And that, is definitely an attitude, and certainly one that I had. But as a public interest litigator, you pretty much have to accept that the odds you will ever be a judge are close to zero, because you take on very controversial cases. And the dimension I want to add to your question is it's different in Arizona. We have a merit selection system, and if you are an excellent judge, then if you are an excellent lawyer, you can become a judge at any stage in your career. You don't have to work on someone's campaign. You don't have to donate to somebody's campaign or something like that. You just have to be an excellent lawyer. And if you are, chances are that you're going to have a conversation like Chief Justice Timmer did, which is, why don't you apply for a judgeship? And I can't tell you the number of people who are judges now who we had conversations with saying, God, you'd probably make a really good judge. So the realm of the possible in becoming a judge is broader here in Arizona than any state that I have any experience with. So definitely put it in your, in your head as a possibility at some point in your career.
So real quick, if that's something you do aspire to, I would suggest meeting judges early on in your career who can help serve as mentors, as well as keep that in mind, track your cases. There's a very long application you have to fill out here in Arizona, and you need to put down information about the cases that you've litigated and opposing counsel and all their contact information. If you do that along the way, it's a lot easier. And I mentioned that you got to put down opposing counsel. Keep in mind, too, that as you litigate, the people who are on the other side of that case are going to be the ones who are going to get to comment about how ethical you are, about how dedicated you are to the law, and about being fair and impartial, even as you're advocating for your client. And tuck that away in the back of your head, too.
Thank you. Okay, well, thank you all for the excellent questions. It's as I said, it's always a pleasure to be back at ASU. And we wish you all the best in the rest of the semester and in finals, and we will look forward to seeing you in practice. So with that, we really stand adjourned.